very much. Good morning. Thanks for coming. It's a good turnout. My name's Paul, as just said, and we've got a great panel from of my colleagues from Reddie and Grose. We've got some patent attorneys, trademark attorneys, design attorneys to talk to you today. Just before we get started, just so we can sort of tailor it a bit to what the audience is like, bit of a show of hands, who's from sort of startups? A few startups, and what about sort of tech companies, SMEs, corporate, that sort of stuff? Not that many. Branding? No one at all. Good luck, Justine. And so who are the rest of you? Like funding, that sort of thing? VCs, any of those? Okay, fine. So that's kind of what Reddie and Grose is all about, really. We like tailoring what we do to our clients and tailor our product effectively to what our clients need, whether that be working to a budget or working to meet specific commercial goals of our clients, or simply just to make your lives as easy as possible. And I guess all the while providing great advice and not just a bunch of options for you to try and wade your way through. So who are Reddie and Grose? We're a firm of patent and trademark attorneys. There's about 60 attorneys, or over 60 attorneys now, based down just down the road in Whitechapel, but also offices in Cambridge and Munich. Big, wide-ranging bunch of patent attorneys working from sort of software and electronics to consumer products, pharmaceuticals, materials, that sort of thing. Also got an excellent team of trademark attorneys and design attorneys working for small and large companies, helping them to protect their brands and designs. So last year alone, we filed over 3,000 patent applications, 800 trademark applications, 300 design applications in more than 80 countries. So we can help you secure protection for whatever you need, wherever you need it, pretty much. So what are we going to be talking about today? We have Zack, who's going to be talking sort of on patents, a bit of an overview on sort of what, why, and how to get a patent, confidentiality, ownership, third-party rights type things of, I guess, the related stuff that goes with patents. Zack's a patent attorney with a background in chemistry and now works with sort of various multinationals and smaller clients in chemical, pharmaceutical, and packaging fields. We're then going to move on to Nick, who is also a patent attorney. He's going to go into a bit more depth on sort of software patents and the issues that might be involved in getting protection for the sort of, I guess, what might be called emerging technologies in that environment, the sort of IoT, AI, that sort of stuff, big data. Nick sort of primarily works at the moment with some clients in electronics and software fields, as you might imagine. He has the rather amazing superpower of being able to speak fluent Japanese. So if any of you do need to be spoken to in Japanese, Nick's the man. At that point, we'll open up to questions on the patent side before moving on to Justine, who's going to talk about trademarks. Justine's obviously a trademark attorney, works with various large and small clients. And Justine's superpower is the ability to complete an Ironman triathlon in what is a ridiculously short amount of time. Then we'll have a few questions on trademarks before finally moving on to Tom, who's sat handily behind me, who's going to talk about designs and both sort of registered and unregistered, i.e. what you get when you pay a fee and what you get for free without really doing anything. Tom is a patent, trademark and design attorney, so he's got the whole smorgasbord of IP and will happily advise you on any one of those, depending on what you need. No one's quite sure of Tom's superpower, but he can fly a plane, or at least he says he can, and he's really rather good at finding excellent quick laps from the Nürburgring on YouTube, so if you ever need anything like that, then he's your man. So to try and hang this talk together, we've come up with a bit of a case study. Our fictitious client, LinkedRing, no prizes for guessing if there's any similarities for other trademarks there. They've come up with this internet-enabled ring It's capable of measuring your heart rate. It's got a little screen. It's got some electronics in there and some haptic feedback, that sort of thing. It can form a mesh network with other rings, so it can transfer data between other people in the room. It's obviously got an accompanying app, which just so happens to be a dating app, which links with a bit of a server in the background to carry out all the matching, work out whether you've got a match nearby, and then tell you and guide you there by using sort of feedback from the ring onto your finger. And I think that's about it. So I will pass you now to Zack.
Thank you, Paul. So when a new client, such as LinkedRing, comes to us, we will assess their commercial needs, their commercial situation, and also the innovation that they come up with. And we will advise on some suitable forms of IP to protect their products and associated branding. So when it comes to inventions, patent protection is an important form of intellectual property protection. But what exactly is a patent? Well, firstly, it's a monopoly right. So what that means is that it can be used to prevent others from doing something. So, for example, with LinkedRing, if they were able to get a patent to protect their ring device, then they may be able to stop others from making the same device, or even potentially making and selling a similar device that falls within the scope of the patent. However, what a patent doesn't do is actually give LinkedRing necessarily the right to actually work their invention. So, for example, if Apple or Samsung had already, a few years ago, had a patent granted for the broad concept or perhaps a specific aspect of the LinkedRing device, then LinkedRing would need to go and seek a license or design around that patent or potentially try and revoke it. Some things that I'll come on to talk a bit more about later on. So while much of my talk is about the importance and how you go about obtaining patent protection, from an early stage, it is really important to be thinking about, well, what other rights are there out there that other parties, other companies have got that might actually stand in your way. Patents have a limited term. This is 20 years from filing, and they are territorial. So this means that a patent that's granted in the UK can't be enforced in the US or Germany. Patents can be used to protect products, such as the LinkedRing device, processes, for instance, processes of manufacture, or potentially certain processes relating to data processing, systems, and potentially uses as well. So why might you actually want a patent? Well, they can be used to protect innovations, but also they are a property right, so they can be sold, bought, licensed, and actually can act as an asset which can contribute to company valuation. Another point is that for startups, I think particularly, it can be a useful tool for helping to attract investment as well. Then again, I should also say why you might not actually want a patent. They do cost money, and they do take time to grant. Unfortunately, it's not like on TV, like in Suits, for example, where I think they showed a patent being granted in a day. That never happens. It usually takes years. Sometimes it might just be that the invention is not patentable. We'll talk a bit more about this later, but it might not be legally possible to actually obtain patent protection for the invention. And then the other thing, sometimes for specific commercial circumstances, it may be best just for a company to keep the invention secret, a trade secret. For example, when it comes to processes of manufacture, sometimes companies decide to keep that secret and don't file patent applications. This is because anything that goes into a patent application, so once a patent application is filed, it will eventually be published. So that information will be out there in the public domain. So I've talked about what, I've talked about why, but how actually do you go about obtaining patent protection for your invention? So, I mentioned earlier that patents are territorial. Now, for a new client such as LinkedRing, who are a UK-based company, the first port of call would most likely be to file a UK patent application. This is because they're a UK company. The UK patent process is quite quick and relatively cheap, and actually quite good quality. So the UK right that's granted will usually be fairly strong. So how does that actually work? Well, the first step is for the invention itself to be conceived. So LinkedRing have come up with this ring device. And for an invention to be patentable, it needs to be new, so over what's come before. It also needs to be non-obvious, so it can't just be a trivial modification of a known device. If it solves a problem or it demonstrates some kind of improvement or effect, then it could well be patentable. Patentable inventions must be capable of being described as well, so that mere speculative kind of high-level ideas may not be patentable. So LinkedRing have come to us with their idea, their invention. At this point, we would then put this into words, and the idea of this is to basically draft a document which defines the scope of the monopoly, so how much the scope of the protection that they want, but also describes the invention in detail. So once this is finalised, it's filed at the UK Patent Office, and they will basically do a search for relevant documents that were published before this patent application was filed, and this is basically to check for this novelty and non-obvious or inventive step requirement. And then what happens after that is something called examination, which is effectively a negotiation between the applicant on the one hand and the patent office. And it's a negotiation to decide on the scope of the monopoly that should be granted. When this concludes, the application grants, and then it becomes a patent, and it can be enforced. So I mentioned that patents are territorial, so I've mentioned this a few times now. So I've shown how we might get protection in the UK, but what about if LinkedRing want to protect their invention in other important markets around the world? Well, clearly they could file applications in a number of countries from the outset, but that would not be the best strategy because it would front-load costs, and also they would have no idea on actually the chances of the patent applications being granted. So what we do, we file a UK application first, as I just discussed, and then basically there are 12 months to make a decision to gather funding, to decide on the key markets. Now, for situations where lots of countries are required, so patent protection is required in a lot of countries, or for instance, LinkedRing want to defer that decision even longer, then there is an international patent process that can be used. And what this does, it basically gives you another 18 months to decide on your key markets, to gather funding, and just to defer those decisions and costs even more. So what happens after 18 months is basically you can choose your jurisdictions of interest. So LinkedRing, they picked out US and Europe as key markets, Japan, and also because their product is being manufactured in China, it was considered that they should probably get some patent protection in China then. So at this 18-month point, basically, it's then possible to have what's effectively separate patent applications in the jurisdictions of interest. And what happens then is that negotiation, that examination then becomes between the applicant and the patent office in US, patent office in Europe, the patent office in China, and the patent office in Japan, etc., etc. Once this is concluded, then those rights will be granted and they could potentially be enforced or licensed, etc. So I've talked a bit about what, why, and how, But I thought I would just finish up by giving some hints, some pointers on things that we think are really important to get right early on, to sort of make life easier as you go through the process. So the first one is ownership. So it's really important to make sure that as a company or an individual, you actually own the rights to your inventions, you actually own the rights to your IP. So in the case of our LinkedRing case study, there was an inventor who was employed by LinkedRing, and his sole job was to come up with inventions. Now in that case, it would be clear cut. The way the law works is that the rights to the invention would be owned by LinkedRing, owned by the company. But if LinkedRing, say, had involved a third party, perhaps a collaborator from another company, or consultants, or contractors, then ownership is a bit less clear-cut. And really, the take-home message is, in those situations, it's really important to nail down at an early stage, by agreement, who owns what. It's also important to record and make a note of anyone who did contribute towards the invention and what contribution they made. So I mentioned earlier briefly about how, in order to get patent protection, the invention must be new. So this is, it must be new over prior publications, but also oral disclosures. So what this means is it's really, really important, and really certainly before a patent application is filed, for you to keep your invention secret. So not telling your mates, not telling investors or customers or collaborators. Now, that may not always be possible, and we would advise not to. However, if you absolutely must disclose, perhaps to an investor, then we would recommend making sure there's a non-disclosure agreement in place that clearly sets out that anything in that meeting that isn't going to be disclosed further, and who actually owns the right to the information. And you need to seek advice with your legal advisors on that. Once a patent application is filed, we'd also recommend that you seek advice before making any public disclosures, just in case they might potentially harm your future innovations, or future potential to protect innovations going forward. So the final thing I wanted to mention to get right early on is, and I mentioned this at the start, is the matter of third-party rights. So the fact that having a patent for your invention isn't enough to actually give you the right to work that invention. We would recommend, before you launch a product, to carry out, via your patent attorney, some kind of risk assessment of the rights that are out there that might prove a risk towards your activities. Being found liable for patent infringement is not trivial. This could lead to significant damages. It could lead to destruction or confiscation of products, and it could also lead to you being stopped from going on and making or selling your products. So it's important to consider third-party rights early on, and do necessary risk assessment about what rights might be out there, and whether they actually pose a risk to your activities. And that's something that we would be able to help with most certainly. Okay, so that's me. Thank you.
Thanks very much, Zack. So we're now going to move on to Nick, who's going to go into a bit more depth on sort of software patents, etc. And then, as I say, we'll take some questions on patents once Nick's finished.
Hello, everyone. So we thought it'd be quite fun today if we tried to present a case study, the kind of thing that we often see in our working lives. My background is physics, and obviously patent attorney, the legal aspects of that, and as Paul mentioned, Japan. So part of my talk will be very much on the aspects of this case study that relate to the patentable aspects of the apparatus, and in particular the software. A lot of what we do when we meet new clients is what we call invention harvesting. There'll be an idea that they'll come to us with, and if it's in apparatus, if it's in the field of apparatus, it's normally quite simple to spot what that is. It's a sort of a tangible thing. You can see it, you can touch it. But more and more these days, everything is implemented in computer, and we have on the computer, and we have to think about computer-implemented inventions and things that are done in software, and they're typically more challenging. It takes us longer to investigate with our clients what might be the interesting and neat bits of their innovation, of their product that might be patentable. Often they're working with many collaborators or pulling software together from all sorts of different sources, and they might be doing something at a sort of quite a high level for an application, or perhaps on a more deeper level inside the computer, and we need to sort of drill down into all of those things. So we've got this case study. It's got some tangible things to it. It's a ring. There's a bit of apparatus. It has some sensors that might pick up your heart rate, that might feed back some information. There's, as Paul mentioned, there's a server in the background. There's data being transmitted between the ring and the server system in the background, and there are other rings in the mix as well. So we're going to be talking really about what aspects of this could be patentable from the perspective of computer-implemented inventions. And just to briefly summarize some of the things that Zack mentioned, you can't get patents for anything. You can only get patents for things that are new, that you've come up with, and for things that are inventive. And by inventive, we just mean clever, a bit clever in some way. They can be new and different to other things, but if they're not really doing something a little bit special, then you can't get patents for those. With computer-implemented inventions, software can be patentable. I'm not sure how many people here think that it can or it can't, but we often have to sort of look at that question. Is it the right kind of patents? Is it the right kind of software that can be patented? And when we're trying to answer that question, we're trying to decide whether or not the computer software that the client has brought to us is doing something technical. And I'll explain what technical might mean with the next slide. Even if we think it's not really very technical and it's a bit on the borderline, we can do other things to protect our clients' assets. The choice of jurisdiction is important, or we might be able to do other things with designs, and Tom will be mentioning a bit of that later. So the reason why we have this slide, what is technical and what is not technical, is that actually in patent law it says that you can't patent software, or at least it says you can't patent computer programs as such, or business methods as such, or methods or presentations of information as such. And over the past 40 years there's been a huge development in case law in trying to decide what is a computer software example as such that you can't patent, and what is computer software that you can patent. And the difference is it doing something technical? Your computer software essentially has to be solving some kind of problem inside the computer at the operating level system, or in getting that computer or that device to interact with other devices. So it's more on a sort of operating system architecture level. It might be improving the way that a person interacts with the computer as a device, so sort of human-computer interaction might be okay. It might be applying the computer in a really technical field, like quite intensive design of in geology, sort of drill bit design, or something where there's a technical process which is quite difficult to achieve. Individuals themselves wouldn't need to do it, they'd need to use the computer as a tool. Things that aren't technical, computer programs that aren't technical, are things where the computer might be doing something new, but the software is really just sort of processing data in the way that computers normally do. It hinges on the intellectual content of the data. So just to give you an example of how that might split out, computer software that does image processing in a new way could be patentable. Computer software that does speech recognition in a new way could be patentable. But perhaps putting Instagram filters on something isn't going to be patentable, because that's really more just about it's fun. It's not really an underlying technical issue. It's just sort of doing something with data at a more superficial level. Not that that's not cool, but it's not what the patent system is for. Social networks, our case study here is sort of a dating application to it, and one of my slides will be a list of patents that Facebook has had granted in Europe, just by way of example. Friends aren't technical, thank goodness. They're friends, and organising data about friends on a social network isn't really considered technical either. But aspects of it, of the way that it's organised, might be. So if we go back to our case study, we've got the linked ring. It's got these sensors, and I just wanted to sort of give you examples in this fictitious case study of what we might be looking for in one of our invention harvesting sessions. So one of the things that we thought might be quite fun is if this is a ring that you wear in a dating app, and you've put in your details and sort of who you'd like to meet into the system, into the back end. And then we thought it might be quite fun if the ring, once it's on and activated, sort of guides you in a direction where you might be able to meet other people that you might end up liking. So in a room like this, it might be able to feed back to you via its haptic sensors a direction to go into, to find people that you like. And that's not an example that we've completely just made up. We did a bit of searching in preparing our talk today. We did a bit of searching on the Patent Office website, the UK Patent Office website, to find examples of other granted patents. And this is one by Walmart, which is a wearable device which guides you around the store to find something with haptic feedback. Another aspect of our case study, if you remember, was sort of the heart rate sensor aspect of it. And there are wearable devices that measure your heart rate and give you a feedback in terms of sort of training. We thought that in this sort of dating environment, it might be quite good if, when you've been guided towards somebody via the haptic feedback, that it detects your heart rate when you meet them, and see if there's a bit of a flurry there, and sort of feeds that back as a measure of compatibility, for example. Now, if the computer software there is a new way of measuring your heart rate, it's sort of using the sensors and analysing the data, that might be technical. Measuring compatibility with somebody, that's getting into the sort of the social network and the kind of the not technical area, so that might not be okay from a patentability perspective. But maybe it detects an increase in heart rate and then does something different, like swaps contact information or establishes the mesh network with the other wearer of the device. So we could begin to take aspects of the heart rate and then the thing that isn't technical and try and make it technical again, just by reframing what we think is the patent as a sort of technical step at the end. And again, this is another example of a patent that we found on the Patent Office website, which I think is trying to stop you driving under the influence. So it determines your heart rate or blood alcohol level, and then it might call your buddies to stop you driving home or order a taxi or something. So in this one, there's been a detection of your biometric state, and then it's taking some action, and the technical aspects of it are really to do with what it does next with the apparatus and the communication network. So social networks themselves aren't necessarily patentable. It's sort of computers doing the things you expect them to do to organize data on an intellectual level, organize contacts. If we could get patents for that, it would stop innovation in a way, because you want computers to be able to do that. We're interested, in a patent perspective, in trying to improve the computer system at a sort of fundamental level. That's basically what patents in the software field are aiming to do. And you'll see that with Facebook, they haven't really, this is just a list of the European patents granted to Facebook in the first part of 2018. You can see that they're all sort of a bit technical sounding, language identification, sub-resolution optical detection. They've all got a sort of link to the underlying apparatus and network itself. That's all I'm going to say about our case study, but just to finish, I thought it might be interesting just to give you an indication of where we might see this field going in the next few years. This is a quote from Benoit Battistelli, the European Patent Office President, back in December 2017. It coincided with a publication that they'd issued to do with the fourth industrial revolution, artificial intelligence, big data, and Internet of Things. And we expect obviously more and more patents to be in this area, and we're going to have to look more and more, increasingly so, at this distinction between the apparatus and technical aspects of it and the things that might not be so technical. The Patent Office are gearing up to deal with those kind of patents, and they've got a fairly well-established test of deciding, and we're quite familiar with that test and can guide our clients and potential clients through it. The purpose of these slides is just to show that there's been a massive uptick in applications filed in this area over the past sort of few years. So that's artificial intelligence published patent applications. The top line there is the US. A much higher number of patents are typically filed in the US than anywhere else. And that's one of the jurisdictions that we would look at for cases that we thought were more borderline. Europe's the orange case there, and obviously the UK is at the bottom. Fewer applications are filed in the UK than Europe or America, simply just because of the market size, but also because European patents can cover the UK, so you get a bit of an overlap there. And similar trends in big data and IoT, big upticks in recent years. And just finishing off, these are the areas of the fourth industrial revolution that the European Patent Office think might be the key areas going forward. And I'm sure that many of you in the audience today are doing things in this field. Thanks very much.
Thanks, Nick. So I think we'll probably open it up for questions. Any questions on the patent side before we move to trademarks? Not a stupid question. I'll pass this to Zack.
Oh, sorry, I couldn't understand if you could hear me or not. Anyway, yeah. So, how long does a patent last? If you say did it over a year and you're still trying to get contacts and networking and things, like, is there a time you have to be wary of?
Okay, so the patent itself will last for 20 years from when it's filed. So that's the first instance where that patent application is sent to the Patent Office, and that date there is your flag in the ground that marks that. And it basically, most countries, and UK is one example, once it's granted, you do have to pay a fee every year, an official fee, to keep it in force, basically.
Thank you very much.
Yeah, in the front here. Should we? I'll repeat the question.
I was just wondering how Brexit will affect patents in the future, and the patents, for instance, if you have patents in the EU right now, whether it will affect it before the end of the 20 years, or whether you have an idea at all for now.
I can take this one if you like. The European Patent Office is basically outside of the EU. It's got nothing to do with the EU. So whether the UK is inside or outside of the EU doesn't really affect patents, is the simple answer. There's potentially a sort of a unitary patent, so a single patent that covers the entire of Europe, which isn't really the case at the moment. You sort of, once you get your granted European patent, you have to split it off into each individual country you need. But that may or may not come in. That's still in the works. Patents, designs and trademarks is a different question, but maybe that will come up later. We've got a very high tech question. What type of assets are most popular to protect in terms of patents in tech? I think I might pass this to Nick.
Yeah, sure. Well, I mean, we do everything really. We do lots of work for people who are preparing applications purely in the related to internet-based offerings, and in that situation, we'll be looking at the software that they've come up with and how it interacts with the graphical user interfaces, and really just trying to see if there's anything there, and then we'll be we'll be choosing the right jurisdiction to file that in. If it's a more technical type thing, it's operating on the operating system level of the computer, we can file that in the UK and in Europe. If it's more borderline, we might go into the US or Japan. The question was what type of assets are protected, what type of inventions, I would perhaps say in answer. I mean, it's really everything. It's really everything. As a firm, we do lots of work in the electronics sector, in telecommunications networks. Zack does chemistry, so there'll be life sciences, and well, he's better qualified to tell you about that than I am, but it really is everything. I think we've seen a huge upsurge in patents relating to medical devices at the European Patent Office lately, but that's really just anecdotal and probably reflects that we're all living a bit longer now.
I've got a question here. Given how software is constantly updated these days, how detailed or broad can you be when patenting software?
Yeah, that's a great question. So there's a big difference between copyright and patents. So patents are essentially trying to cover new functionality. And when we prepare a patent application for anything, it's our job to write what we call a detailed description of the invention, and that literally just has to be as detailed as we can make it. But if it was software, we call it boxes and sticks, as almost. It's a flow chart. We're sort of trying to illustrate what are the core steps of what we think is the inventive concept. And that will be a sub-part of what you've come up with. So you'll have a product which will do all sorts of things, and we will sit down with it and try and identify the key aspects, sort of the bottlenecks, the things where it's really doing something quite clever, and then home in on those. And then we write a detailed description of functionally what we think is going on there. And then at the end, we write a claim, and the claim is really the definition of the legal protection you get. So if we've done that correctly, we will have a detailed description of, say, 15 to 20 pages. It can be longer or shorter, depending on how complicated the invention is. We just have pseudocode in there, something very basic, and then we have a legal definition at the end. If your invention changes, then in terms of its implementation, it doesn't really matter. If it changes in terms of what it's doing, then we might need to look at the patent application again and check that the legal protection we've tried to get in there is still covering what you're doing. But even if it doesn't cover what you do anymore, as Zack said, that's still an asset, so you might still want to hang on to that application and sort of take it forward.
Hi, hello, thank you very much. I have a question. There is a lot of AI, machine learning, software components relying on Azure or Amazon WS. So two questions really. What do you see from your window coming up? And does data scientists patent those software based on machine learning on those cloud instances? And two, how do you move to evaluation and evaluation of those patents actually?
Let me answer the second question first. If by evaluation of those patents you mean financially, that isn't something that we do. We are in the process of, we're in the business of getting registered rights for people and advising them in relation with other registered rights. And we partner with people in that area who would need valuation or would be seeking to sort of capitalize or monetize what they've come up with. In terms of AI, it's really to do with so AI is a great example because it's pure software, but then it's really, from a patenting perspective, if it's going to work as a patent, it needs to be applied to something that makes it technical. So pure AI, just the idea of using a computer to analyze data and come up with things, might not be patentable. If it's just sort of trying to imitate a human, for example, that great AI, really fascinating, but not really going to be patentable. If it's AI on MRI trying to identify a tumor or something more quickly, in a way, by collating together all of the information that people would do and perhaps adding something to it, then because that's an application of AI in a in a technical area of, say, image processing in this case, or making a determination. That's the kind of thing that we would expect to see.
I think we'll just take one more question and then quickly answer the two we've got via Slido and then move on.
Great, thank you. Following on from the first question on that, on the app, could you, 12 pages of legal writing sounds very expensive. Can you just give an indication as to how much the process costs?
Yeah, we can. As Zack said, it is a lot of money. I mean, it depends really on the technical field. The first instance is to try and prepare the patent application and get the claims right and get all of the information into it. And for that, you are looking at legal work of several £1,000s. The official fees at the UK Patent Office are quite small, so they're just a few £100s. So in the first year, trying to get it on file, you know, you're looking at, I don't know, £5,000 or more or a bit less. It depends what you do. Going forward, you know, the legal fees, the filing fees at the European Patent Office are several €1,000s just to file a European patent application, because you are essentially covering all of the countries that participate in what's called the European Patent Organisation, not the EU, the European Patent Organisation. And then, you know, going forward, each time you're filing an application or doing some work, it requires analysis, and you know the costs are typically a few £1,000s each significant step of the process. And as Zack was saying, it can burgeon out quite quickly if you're filing a worldwide portfolio. So budgeting is a very important thing, and we do a lot of work trying to tell our clients in advance, you know, what the costs will be over the next 5 years. Hopefully you are building up a valuable asset, a valuable portfolio that when you get to your exit adds to the value of your business. You know, that's the point. That's what you're spending the money on.
To specifically answer that question, yes, you should consider it when you're trying to raise funds. I suspect it's going to be it's going to be a good portion of your budget in the first year, I would have thought, because as Zack said, you need to file before you disclose to anybody. Therefore, you need to do it right up front. So getting the funds in place to do that as soon as you can is always a good thing. Well, maybe we'll try and quickly answer these questions. We should probably move on because we're running out of time. Easiest countries to work with, but basically the big jurisdictions are all very similar, very easy to work with. So Europe, the UK, US, but even now China is pretty easy to work with in terms of actually securing protection. It's very much like the EPO now. And Japan has always been easy. Australia is basically based on the UK. If you want to go to sort of far-flung countries in the middle of nowhere, then it's going to be a different process. But all 99% of applicants find the process fairly straightforward because it's very similar throughout the world. IP in the age of open source. Well, if you don't protect your IP, then you can't necessarily offer it up as open source. Getting protection for it and deciding what to do with that protection is a different question, really. Once you've protected it, you can then decide to give it away for free if you want, but actually enabling that, actually if you've got something in the background that pinpoints what your IP is, enables you to use it in any way you wish, including open source. I think we'll probably move on because otherwise you'll be sat here all the way through lunch, and we won't have even spoken about trademarks. So Justine.
Hello. I am going to talk about trademarks. Why protect your brand? I often think, why not protect your brand? I've had a few people come to me in the past and say, oh no, we've been using our brand for years. Nobody's going to copy us. But you've worked hard to build it up, gain the recognition, and attract consumer loyalty. So there's been an example recently in my sort of area of work. I was in discussions with someone who was really interested in protecting their brand, but at the time it just wasn't business critical. 7 or 8 months down the line, they've said, oh no, we found someone, has filed a new application. It's the same name as ours. They're covering the same goods. What can you do about it? Luckily, all is not lost. This business is successful. They've been operating for about 20 odd years, so they do have some rights in place. Unregistered rights are, you can use that to enforce against others, but it's trickier and it costs more money generally. So Trademarks gives you a monopoly right to use your brand, your logo, your name in respect of goods or services that you've protected it for. And it enables you to prevent others from using the same or a similar mark or name that could have the potential to confuse customers in the same marketplace as yours. So there are financial benefits. Obviously, if you're making your millions with your startup in a few years and you're looking to sell, most buyers will expect you to have a solid IP portfolio in place. Obviously, with the software on the patent side, but also with your trademarks as well. Obviously, you can license your IP rights, so it means that you still sort of maintain the control over the way in someone uses it, and you can obviously benefit from it sort of extending to a sort of broader scope and territory. If you don't protect your brand, you obviously then run the risk of copycats or competitors sort of stepping into your market and damaging that reputation that you've worked so hard to build. This is just a little quote from Phil Knight, the founder of Nike. I don't know if any of you read his book Shoe Dog. Thoroughly recommend it. But he basically said, imitation is flattery, but knockoff is theft. And in a case of an Asian company who was blatantly copying his designs of his trainers, he said that this theft was absolutely diabolical. So it's a real case of getting everything in place so that if something arises, you can do something about it. So what can be trademarked? Well, I've used the example of Apple. I suspect most of you have got iPhones, iPads, Macs, everything. But it might be a few icons on there that you'd be surprised to see that are protected. Obviously, they've got their word mark registered. They've got their Apple logo, but they've also got some of the FaceTime icon, their Safari icon, their messaging, some of the sort of newer brands that they're launching, Animoji, which I didn't know about until only the other day, and took great delight in trying that out on Paul's iPhone. But they've also got protection of their store layout. So you might go into Westfield and go into their store and it looks exactly the same as every other Apple store that you've been into. And they've done this, these marks are all registered in the EU, but they've done this around the world as well. They've had issues with sort of copycats in China that have copied the layout of their store down to the very sort of minute detail, and they're selling the copycat products. So who knows, when someone, Mr. Joe Bloggs, walks in off the street and he goes into what he thinks is an Apple store to buy himself a new Apple iPad, but actually he's just being completely ripped off and he has no idea about it. So Apple have worked really hard to protect as much as they can about the whole brand. And actually just in the EU alone, they have nearly 550 registrations. So they've obviously spent a lot of money, a lot of time to get their sort of branding in place. and protected. So obviously, you can protect your word, you can protect your logo, you can protect sounds, the Intel sound, doom, 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 that's protected. The shape of your product, for example, Toblerone, the older style, before they changed to more troughs than peaks. That's protected. Colour marks, you can get protection for that. So Tiffany's, the jewellery, I'm sure most of the guys in the audience will have bought many gifts for their other halves from Tiffany's. That's a very popular colour of mine. But most commonly, people go and protect the words or their logos. So how do you get something protected as a trademark? Well, in the UK and in the EU, it's actually quite a fast process. It's much faster to get trademark protection than to get patent protection. In the UK, it can be as quick as 4 to 5 months. In the EU, which is you can file in national countries, or you can file sort of what is known as an EUTM. So it's sort of the pan-EU system covering, at the moment, all 28 member states. And that you can get a registration within about sort of 5 to 6 months. So it's still a pretty quick process. So this example on the slide is what would sort of be the timescale in the UK. You file your application. The examiner will have a look at it, give the yes or no. There might be a couple of niggles. There might be some sort of bigger issues that we'd need to explore depending on the mark and the goods that you've sort of trying to protect it for. Once the examiner gives the go-ahead, the application is published in a trademark journal, and this generally triggers what's known as the opposition period. So it gives other people the opportunity to object to your trademark application going through to registration if they see it being a bit of an issue, and sort of don't want you to have that sort of right on the register. The great thing about trademarks is that once it's registered for 10 years, and you can renew that indefinitely. So it doesn't have a sort of shelf life like patents do of 20 years. You can keep renewing your trademark registration every 10 years. 5 years, for the first 5 years after you've registered it, you get it for free. You don't need to, well, not for free, but you don't need to be using it. After the 5 years, if someone wanted to try and attack your registration on grounds that you're not using it, you'd need to be in a position to show evidence, sales figures, invoices, brochures, adverts, your website, things like that, to show that you are using your mark in relation to the goods or services that you've protected. Otherwise, you run the risk of losing your registration. So it's really important to sort of keep piling in all of the evidence just in case someone tries to come after you and attack you. Trademarks are cheaper than patents as well. It's another benefit of them, I think. In the UK, you can get a trademark official fee from £170. So it's a great investment. EU, as I said, if you cover all the 28 member states, that starts from €850. So it's a little bit more, but you're getting protection in 28 different countries. So it's perfect to go for that. So turning back onto to the case study, which I think is probably where the name itself, LinkedRing, comes into play a little bit more in terms of the trademark side. When a client comes to us for advice on their branding, we'd like to have a chat with them to find out what their business is all about, what their plans are, where they want to operate, in their long-term plans. Do they want to go overseas? Are they planning to stay UK-based? Do they plan to extend their brand to everything in the next 5 years, 10 years, or whatever. It also depends on what branding they're going to be using. Obviously, we've got the example of LinkedRing with the orange logo, but you know, how are they going to be using it? Do they want to use it just in that colorway, or are they thinking of maybe, I don't know, setting up a sort of sub-brand, you know, a different app that would have maybe a pink background colorway? So you can obviously get sort of if the color is not going to be a feature when you're planning to register it, you can go for sort of the grayscale options, and then obviously, you know, if they're wanting to have it on an app, do they want to protect the icon with the sort of ring, or do they want to go for the word mark, linked ring? I don't know if any of you have maybe thought, oh, there could be another brand that might be a problem. But you know, obviously we would think, let's do some searching. In most cases, things might not be so obvious, but in this case, surprise, surprise, we came across LinkedIn. Now, this is what LinkedIn have registered, just some of their registrations on the EU register. They've got the black colorway of the logo, the word mark, and then their IN icon, which you'd see on the app. They don't have the blue icon or the blue logo registered, but they obviously use it, so they have some rights in that colorway as well. So what have they got their marks protected for? Well, I've literally pulled off the wording from their registrations. Online social networking services, computer software, computer hardware, online business networking, entertainment and educational services, and a huge list of other goods and services. So you can really file quite a broad specification that could cover, you know, I mean, they're covering social networking services per se. And that would, you know, sort of dip into the sort of dating social media aspects, and obviously could pose a problem to our new client LinkedRing, who wants to, you know, set up a sort of dating and social media, social networking business. So what could we do? Well, as an initial review, we would say, well, I mean, in my personal opinion, I think the word mark would be a bit too risky. LinkedIn, LinkedRing. I mean, even the guys, when we've been discussing it over the last few days, keep saying LinkedIn, and I keep saying, don't say it. It's LinkedRing. So there's obviously sort of clear potential for confusion already just by saying the words. So I wouldn't go for the words. I think the app icon is probably safe. You know, the words are different, the letters are different, the colours, you know, it's orange, and it's far enough removed from sort of stepping on toes of LinkedIn into their app icon. I think there is a risk with the linked ring with the logo. You know, obviously you still have that oral similarity between the marks, and you know, there's this sort of little icon, there's sort of square around the wording, and then obviously you want to bring protecting it for pretty similar, if not identical, services. So we'll obviously advise that there's a risk, but you know, if the client wants to go ahead, then it's our job to find a strategy that can get them the best form of protection possible without stepping on the toes of these identified earlier rights. It might be a case of, you know, sort of tweaking the logo a little bit, seeing, you know, stripping it down to see what protection we can get in place, you know, such as the icon alone, and then obviously drafting a list of the goods and services that you want to have the protection for, but making sure that, you know, you're trying to sort of reduce the risk of overlap between LinkedIn's sort of business networking and and their sort of related goods. So, yeah, I mean, that's an obvious issue that, you know, sort of case study that would come up. It wouldn't come up. You know, it wouldn't be that obvious in most situations. But this is why we like to get searches done at the very sort of initial phase of the creation of your brand, because, you know, if you're a startup and you're investing all of your time and your effort and financial investments into sort of getting this brand, you know, off and into the market, you need to make sure that you're not going to run into any obvious hurdles at the very outset. So, you know, even just doing some quick searching online, it can really save you a lot of money, a lot of hassle in the long run. Thank you.
Thanks, Justine. I think probably in the interest of time, maybe we'll bypass questions at this stage and have some at the end if we have a bit of time. And I might even ask Tom to keep it a bit brief on the designs. 4 minutes. He's telling me 4 minutes. That's all we've got left. Hang on. Not you, Tom. Them. Hang on.
Thanks for bearing with us, everybody. The third major form of IP rights that we're going to talk about is designs. And being designs, I thought it was a great chance to get this lovely picture of a BMW Isetta from the 50s up on screen, which also conveniently fits with our colour scheme of orange and yellow. Design protects the appearance of products. We've been hearing about patents which protect the technical function of things. We've been hearing about brands which protect the way that products are marketed. Designs fits into that overview of IP rights by protecting the way things look. This is probably a good example, although clearly this is not new tech. At the time, in the 50s, it was new, and there would have been the potential for patent protection for elements of this. There would have been, obviously, the BMW brand and the name Isetta, both protectable as trademarks, and the appearance of the vehicle, aspects of the vehicle, protectable as design. So a good example of the fact that these rights are not mutually exclusive. You can have more than one in the same type of vehicle. Designs protect overall vehicles, as an example, overall products, individual elements of products, the packaging of products, the elements of apps and things that go with them, as we'll come on to. So it's quite a broad remit. This was an example of a major case that you probably would have heard of, the big battle between Apple and Samsung. There were some patent elements to it, but also some design patent or registered design elements to it as well, which resulted in Samsung owing Apple the princely sum of $533 million. So just an example that design rights can be quite powerful. You probably also heard on the flip side about the Trunky case, where the inventor was unable to prevent a particular copycat product being sold in the UK, which on the face of it was a bit of a restriction on the scope of designs and perhaps casting some doubt on the use of designs. But actually, what you don't get to hear about, and I have heard about from talking to the chap who was involved in that business, is that they used their registration of their design to very good effect in tackling 3,000 odd issues. So even though they famously lost in the Supreme Court on that particular case, they've had a lot of success in protecting their design. Where do designs fit in here? There are hardware aspects. So the shape and the appearance and the material finish of the ring, the hardware. Obviously, most modern products, particularly IoT products, have hardware, software. So there are elements of the hardware that are protectable. That's the overall appearance, but also individual elements of it. It may be the first ring to have a screen on it. It may be the first ring to have a particular arrangement of sensors, possibly in those colors, or at least in that arrangement. So a few things there. The app icon, Justine was talking about the fact that's protectable with trademarks, also protectable as a design, and it's an example of the overlap between different types of IP rights. The benefit with designs is you could find that that's cheaper than protecting it as a trademark. And then the appearance of the app that goes with the hardware. The overall appearance of the front page, design themes that run through the app as you navigate through it from page to page, capturing those and protecting them as a design is a great way of preventing other people from copying that particular appearance. this is just to give you a sense that designs are great because you get a lot for free. Potentially, you get five types of IP protection simply by having developed something and captured it. The downside with these is they're relatively weak rights. If you were to try and enforce them against somebody who was copying, you would have to go through a process of proving what the design is, when did you create it, who created it, what did it look like when you created it, what are the various revisions that it's gone through. All quite difficult. Good reason to keep some good records, but quite challenging if you needed to use these. So the main benefit of going on to paying a bit of money and going to the registered side of things is that it's much more certain. You don't have to worry about proving all of that stuff. You have a registration. It's got evidence of ownership because you've got your name on the official certificate as being the owner. It's dated, so something you can prove when it was that you created a design. You can see the images of it, so it's fixed. You know, there's a good. It's easy for people to understand what it is that's protected at what point. They're cheap, very cheap, particularly compared to patents. They're fast. You can get a design registered in the European Union in about 2 days, 3 days if things are going slowly. They can last longer than patents, 25 years, up from 20 years for patents. They're not examined, so it's a deposit system. You file it, you know it's going to get registered. You're not going to run risk of having it rejected, provided you meet some basic formal requirements. There's a grace period, so even for something which you've already been testing the market with, so something that's been out there for less than 12 months, you can still claw back some design protection for something like that, versus patents where you have to get in there and protect before there's any disclosures to anybody else. And customs, I mean, if you're in the business of making hardware, or hardware is at least part of your offering, then registering designs with customs is a great way of preventing the stem of copycat or lookalike products coming into the UK, Europe. So very briefly, if you were in the business of protecting our LinkedIn, LinkedRing, good example of what we've been talking about. There are various ways you can do it. You can do it in the most obvious way, which is just use an image of the color version of your product, and you can put that in, pay your fee, and treat that as job done. Or if you think about it more carefully, there are actually other things you can do. And major cases like the Trunky case have highlighted the fact that actually doing things using grayscale type images, where it shows the tonal contrast between various bits of the hardware but not specific colors, can broaden your protection. And going down to black and white line drawings, if it's the overall shape that's important, rather than particular colors or particular material finishes, and the shape is new, then actually stripping it right back to black and white line drawings is the broadest protection available. Thinking about the app icon and the appearance of the app, again, you can do it in color if the colors are important to you, if that's part of your branding and people are going to associate those colors with you. Protecting color is a good move. If you want to protect the arrangement of information on the screen, the arrangement of windows, how those windows might move as you navigate through the screen. But the colors are not especially important, and you'd be terribly upset if you found somebody using a very similar arrangement of windows but in different colors. Then stripping it back and going for grayscale is often a good move. So just finishing off, what else to think about? Marking of designs is important, whether it's the stuff that you get for free, copyright notice, copyright 2018, designs, marking your designs as being proprietary rights is all a good idea to keep people away or act as a deterrent. Keeping good records, if you end up in a design dispute, having good records about who created what, when, what was the design process, the revisions that it went through, you may need to provide all of that. Think about protecting updates of your designs. You could treat the job done on the day that you file your first design, but as we all know, things are developing all the time, and as there are changes and facelifts and revisions to the software, then keeping the design protection in line with that can be a very sensible move. Like with patents and with trademarks, do think about third-party rights. Designs are relatively difficult to search for. It's quite easy to search in the name of one particular company. So if you think that if your main aim is to try and have something that's reminiscent of something that Apple might have produced, then you can search and see what designs a particular business like Apple has. But searching to see what everybody else has can be a fairly laborious process and involves looking on Google Images for unregistered designs as well as on the register for registered designs. And in the interest of keeping it quick, we'll finish there.
Thanks. Thanks, Tom. Just before we move to questions, you've all got a feedback form on your chairs. If you could fill that in, that would be superb. But if we do have any questions on trademarks and designs, Yeah.
Once you've registered your trademark, if you then change your logo, how easy is that to then update?
Once you've filed your application, the mark it can't be changed. You can, in terms of the goods and services, you can narrow them down, but the mark itself, it can't change at all once it's filed. So yeah, if you wanted to then change your brand at a later date, then yeah, you would need to file a new trademark application.
Any more? Yeah, I think we answered that before. I don't know whether there's any. Probably isn't any design and trademark aspects in terms of open source, but are we done? Oh, one more.
Should you be violating your design, like product design, patent intentionally? Like how you can search up like trademarks or patents? Can you search for design or product design?
Yes, you can. You can certainly search by people going to the trouble of registering their designs means that they're available on a public register. So the UK Intellectual Property Office, the European Intellectual Property Office.
Since for the process of patenting a design, you don't have any examination, how would one know that you're violating one?
Exactly. So it's because it's a deposit system and there's no examination, so they're not going to tell you whether it's the same design as anything that's gone before it. Through the process of registering your design, no one's going to tell you the answer to that. So if you're concerned about whether you're going to be infringing anybody's design rights, then it's up to you to be searching them, which is normally a combination of searching what's on the register, which can be done with keywords and things, but also searching on Google Images. I mean, most of our clients have got a pretty good understanding of what the market looks like and what other people's designs are, and therefore normally most of that falls to them. But certainly there's all sorts of searching that can be done.
That looks like it's it. So thanks very much for those of you that stayed on to the end. Sorry we ran a bit late. We started a bit late and probably ran a bit over it as well. But thanks for coming. Hope you enjoyed it.